To today's Research Data Canada webinar. We have a guest panelist today who I'll introduce shortly. Before I do that, I've got just a few administrative points to cover. We do record the session, so both the audio and animated slide deck will be available via the RDC webinar site as well as Canary's YouTube channel. And anyone who has registered for today's webinar will receive a communication as soon as that recording is available. The slide deck will also be available separately as a downloadable slide deck. And typically those are available pretty quickly after the webinar, typically by the next day. Since this, we always pass on. Actually, James, I think the slide deck has moved ahead a bit there. If you want to go back to the second slide. This is Canary and Research Data Canada standard webinar recording policy, particularly appropriate today since our topic is all about privacy. While we do record the webinar, only the panelists have audio enabled. So the only indication of personal information is in the chat or in the Q&A based on the name that you logged in with. Neither of those are included in the recording, so none of the names, if you pose questions, will be included. And we also enable the ability to ask questions anonymously in the Q&A panel. And that also highlights our preference for you to use the Q&A panel. It's a very useful tool because typically what I will do is queue the questions, and James will pause once or twice just to see if there's any immediate questions that would be appropriate to answer. Otherwise, I will queue the questions until James has finished his presentation. So you can use the chat, but I would ask that you use Q&A to help us with our queuing activity, especially given the number of registration participants on the call today. We will, I guess that's it probably for the administrative bits, and which is also provided in English and French on the screen at this time. So as I mentioned, this is a guest webinar for RDC, and our presenter today is James MacGregor, who's the Public Knowledge Project, or PKP, as it's known. He's the Associate Director of Strategic Projects and Services. James has been working with PKP for over a decade now, and I've had the opportunity to meet James once or twice. And his focus is around infrastructure building and community management. And he is currently responsible for coordinating the larger PKP community approach to the GDPR, among other things. So I really appreciate James coming on as our guest presenter today. And I did include a link at the top of the chat today to the GDPR guidebook for PKP users, which James will reference. So whether or not you have a chance to look at it today, I certainly would recommend that you take the opportunity to look at it after. So James, I will mute myself and pass it over to you.
Perfect. Thanks, Mark, and thanks again for providing me with the opportunity to talk about this a little bit. There we go. I'm going to break this into about 3 sections today. The first one is just to talk about what GDPR is, what our understanding of it is from the PKP team. The second bit is how to go about complying with GDPR, what some considerations that you may want to look at would be. And the third bit is just 1 or 2 use cases or examples of our thought process that went into this entire process. Before I get there, I do want to say I will pause briefly for questions between each section, and we can have questions at the end. I'm going to try to talk for no more than a half hour, give or take, to provide as much time as possible for any questions at the end of it here. So as some of you may know, PKP developed a GDPR guidebook for users of our software. This was developed between January and May of 2018 and was developed with partnerships from a number of different areas, individuals and organizations. Most specifically, most prominently, our development partners in EU, being journal.fi, which is a federal Finnish journal publishing platform, the Free University of Berlin and Heidelberg University, a number of hosted clients who brought their concerns to us and worked with us through this process just to make sure that their concerns were met, and also general community members on the PKP forum and via GitHub. PKP is maybe a bit of a strange institution in that we're a software developer, but we are also a service provider and an infrastructure provider too. So we have a number of different hats that we wear that we had to sort of keep in mind as we went through this process of developing the guidebook and developing our own practices. The process by which we did this was actually fairly straightforward. The team that we worked with contributed to understanding the GDPR, in particular from an EU perspective, which is important to us because we're a Canadian group and we didn't really have the familiarity that they did with this particular issue. The entire team assisted in scoping technical challenges, so changes that we would have to make to the software itself, future requests and that kind of stuff. Assisted in reading, writing, and reviewing all of the documentation that we've done so far. Did do some limited legal review, and I should note that this was all very much country specific or platform specific, so there was no general legal review of the guidebook that we wrote and disseminated, but we did have legal teams in various countries look at it and just make sure, at least for their particular contexts, it's satisfied. And then finally, we had a lot of code contributions from the PKP developers, but also from these development partners. So I should actually just note up front who I am. I am a long-time PKP associate. I'm the Associate Director of Strategic Projects and Services at the moment. I manage our hosting infrastructure and also contribute to a number of the various projects that we have in place or that we're working on at this point. I did coordinate this larger GDPR team, but I am not a lawyer. And this is the only meme I could find. I'm actually not a programmer either. I pretend to be one sometimes, but I definitely don't pretend to be a lawyer. And all that to say that the advice that I'm going to be giving here today, or what I'm going to talk about today, is from my own personal experience based on what we've done at PKP and what we understand to be the case. However, in your own particular cases, when you undertake this or as you undertake it, you should also have your own internal legal review. And what I talk about today isn't a substitute for that. And maybe one final note, our understanding, and honestly everybody's understanding of GDPR as far as I'm concerned, has been iterative, and it will evolve over time and improve over time. We've been hearing this from every community that we've talked to. The biggest takeaway that I would give, and which I actually have given to our own hosted clients internally, is just not to panic, to sort of just get started, start reading what's going on, and just make your best effort at understanding what compliance means for GDPR and how you would go about doing that, and to start at least making steps towards that level of compliance. My understanding is that it's going to be some time before we see any sort of actual policing of this in any significant way. So right now, it's time to get your ducks in a row and just make sure you're ready and you understand the issue. All right, step one, what is the GDPR? And I'm just going to step through some of the definitions that we've called together and that we've provided for ourselves. These are all included in the guidebook that we've provided for PKP users. And that will be included in the link later on. So you can refer to them there. The slide deck will be available later on too, but I'll just kind of go through these relatively quickly. First of all, GDPR stands for General Data Protection Regulation. This is the new regulation from the European Union that dictates how data controllers and data processors must adhere to specific responsibilities with respect to the collection, processing, storage, and destruction of any personally identifying data. And that is specifically data that can identify a particular data subject. In my mind, it really is, it's a big set of regulations, but it's a common sense regulation. Basically what it boils down to is that if you're a data processor or data controller, that is if you manage data on behalf of another person or individual that is private in nature, you should know how you process it. You should be able to describe how you process it. You should have adequate protections in place with respect to the processing of it. And the individual, in this case the data subject, should have recourse to understand how that's done and recourse to assert their rights. And we'll be looking at some of those rights here in a little bit. Very quickly, the difference between a data controller and a data processor and a data subject. I'll actually start from the bottom. The data subject is the individual of whom the private information is being processed. So this is somebody who visits your website, has an IP address that's tracked in a log file somewhere. Somebody who registers for an account, includes their username, email address, first and last name, biography, mailing address. Somebody who uses a credit card somewhere, anything like that. A data controller is the entity that dictates the terms for the processing of that data. So it's typically, we describe this as the person who runs the website. In our case, for PKP, it is the editorial management team, and they're the folks who write up the privacy policies and publish those and sort of dictate how that's run. The data processor is the entity that manages the processing of the data on behalf of the controller. And this may be the same group or may be separate, but this would be, say, at the server level. So anybody who administers a system and actually manages the back end or sort of controls the actual processes by which the content is processed, that's the data processor. Data subjects have a significant number of rights, and we'll sort of gloss over these, but in short form, that's the right to be informed. So they should know what information is being collected and how it's being processed. They should have the right of access, namely they should have the ability to access the private information that's collected from them. They should have the right of rectification if they see that something is incorrect. The right to erasure is a big one. So this is the ability or the right for a data subject to ask that, say, records be deleted that they don't want to have floating around anymore. They have the right to restrict processing, right to data portability. So if they want, say, a bundle of their information, they should be able to have access to that. One example would be the ability, say, if you have a Facebook account, to actually download your entire archive of all published content, all that stuff. You can do that via Facebook. But if you have, recourse to a CSV file or something like that with your information, that suffices. They have the right to object, including the right to withdraw consent, and we'll get to that in a little bit as well. Consent is a kind of an interesting topic. And they also have the right to be not to be subject to automated decision-making, including profiling. So in short, in order to adhere to the GDPR, people acting in the role of data controller in conjunction with those serving as a data processor must provide adequate means for data subjects to assert these rights. Pretty simple. Personally identifying information, the GDPR does define this. This is any information that can be used to identify a person. So that includes email addresses, first and last names, mailing addresses, phone numbers, social network posts, and even IP addresses. There are opportunities for exemption in terms of having these rights addressed. And in our context, the biggest one is the right for the data controller to retain certain access to content if it is journalistic or scholarly in nature, or if it is otherwise in the public interest. And this is explicitly outlined in the GDPR. This is important to understand. From a research perspective and from a scholarly publishing perspective. So there is the right to reconcile the right to the protection of personal data pursuant to this regulation with the right to freedom of expression and information, including processing for journalistic purposes and the purposes of academic, artistic, or literary expression. Our understanding of this, and again, this has been reviewed and confirmed by our partners in the EU, is that when and if you are collecting data for, say, research publication or some sort of research effort, say in the PKP or the OJS journal context, this would be online reviews, comments on the article that come from a reviewer or an editor, any of the editorial history, and even, say, author names attached to a particular paper, the abstract itself. Any of that information is exempt from the GDPR regulation in that folks can't just come and ask for that to be erased. This is part of a scholarly record, and the scholarly record here in this case is exempt from that particular form of legislation or access. And one note on consent. I did want to come back to this. To process private data, you need a lawful basis for processing personal data. And there are a number of different lawful bases for requesting this, requiring this. And the most common one, at least in our context, would be consent. And this can be in the form of an explicit or implicit consent. So think of when you register for a website, to adhere to GDPR compliance, any website registration form must have an explicit opt-in option to consent for that data to be processed and stored. So that consent provides the legal basis for the processing of that data in the background. We'll maybe return to this when we talk about some of the particular use cases that we looked at as PKP. Before I continue, maybe just a quick pause for questions to see if there are any at this point. And I'm not seeing any in the Q&A.
And actually, maybe while we give people a couple minutes, James, I should have highlighted at the start that while your presentation will have a degree of focus on the PKP suite in terms of, as a journal publishing platform, but a lot of the concepts and the discussion points are relevant to any privacy context, and in particular scholarly research, publicly funded research, and the like.
So absolutely.
Should have highlighted that at the start.
Yeah, and I should acknowledge too that that's not my sort of the research area is not my particular area of focus or of expertise. I used to be in a cognitive science lab at Simon Fraser University Library way back in the day, and that's a long time ago now. But yeah, if there are questions about that, I should be able to answer them.
So there is one question, James. So did you say in so many words that research data is exempt from the GDPR?
Right, and let me clarify that a little bit. So my assumption is that if you're collecting research data, so you're conducting, say, an experiment, and you're getting data that contains personally identifiable information, you've already gone through a process to, say, get sort of an agreement from your university that this is okay. You've gone to the ethics board, all that stuff, and you do have a consent statement there to gather that information. And that's offline. That's not sort of on the web or anything. That's just your own research data. You should still read and understand the GDPR in terms of sharing that research data. My understanding is that as long as it's, as long as you would adhere to your sort of the ethics proposal and properly anonymize content, if there's no personally identifying information there, number one, that's probably the quickest way to not have to worry too much about the GDPR. If there is personally identifying information in there, you do have to have a good legal basis for containing that and for continuing to have that. So if that is for sure a part of the scholarly record, that's probably fine, but you should still take adequate steps to protect it and to otherwise manage it, to destroy it when it's no longer necessary to have it. And I'll get to some of these sort of compliance steps later on.
And there's another question. If the data falls into an exempt category, and I think maybe this concept of personally identifiable information being exempt is maybe misplaced, because any collection of personally identifiable information must follow the GDPR and provide the appropriate responses to the terms of that GDPR. So I think that's maybe thinking that certain things are exempt. There are certain exemptions based on things like the right to erasure.
Exactly.
Like so just to clarify that, but the question is, if the data falls into an exempt category, do controller and processor inform participants in a consent form? Is it possible if data becomes exempt after original consent is signed? And what happens in this case with relation to informing a subject?
If the data becomes exempt later on.
Yeah, I'm not sure I fully understand the question, James, but again, I think maybe what I might suggest is you go on with the how do I comply section, and it may become a little clearer about exactly this concept of exemptions. And again, the exemptions are a fairly defined type of exemption based on the different parameters of the GDPR. So maybe if you go ahead, we might answer some of those questions.
Sure, yeah. And I should actually, I'll just maybe reiterate too, because so much of our process in this was looking at what to do with editorial history of journals, basically, is sort of what it came down to. So we have two categories of data. We've got, user registration data, which we can sort of adhere to GDPR, sort of like we could delete, destroy all that without any effect. But then we have editorial history and other content that pertains to the actual history of the journal and is there as part of the scholarly record, which has different exemptions. So it's not, we don't necessarily have to erase that if we were a journal, that kind of thing. So again, the context that I've been working in has been very specifically around the journal, the publishing context, but there are other there's plenty of information online that would address the specific sort of the research data question as well, if it's not the exact same answer. All right, so yeah, just gonna go through 4 or 5 steps on how to comply. And this is what we've been recommending that our community do. Number 1 is establish your role. Are you a data processor or a data controller? You may be both. For example, PKP is both. Number 2 is to do a system review. So you'd really have to figure out what P2 or PII, that's private, personally identifiable information. What information do you collect? How is it processed? How is it stored? And how is it protected? And then finally, also, if you have that legal basis by which it's been requested. So that's basically sort of a system scan just to get an overall idea of what you're looking at and what the problem area is effectively. Again, from our context, we have websites with backend databases. So the databases store information, but the websites themselves transfer information. So we have to have an entire understanding of how that works from our perspective. Step 3 would be to take steps to protect your data and to also reduce your collection footprint. This is actually kind of a neat and fairly key part of the regulation. Number 1, you do have to establish and quite literally document your data management practices, how you manage that stuff. You don't have to necessarily publish your practices, but you do have to have it documented and available for audits if audits take place. You should encrypt what you can. Where necessary. So, I mean, I wouldn't unnecessarily go crazy with encryption, but for example, in the OJS context, again, we encrypt user passwords, and there is the option to encrypt IP information if that's collected as well. The big one here is, I think, don't collect data you don't need, and I feel like folks tend to sort of be a little bit over enthusiastic about what they ask for from users. So again, from our context, if somebody registers for an account on an OJS website, we ask for their first name, last name, but also gender, prefix, biography, mailing address, et cetera, et cetera. Maybe not all of that is necessary. So really just try and focus on the needs when it comes to collecting personal information. And then finally, only store data for as long as it's required. That's another big one. You should make any reasonable attempt to destroy data as soon as it's not required anymore. Next, you should develop and provide adequate privacy processes and rules. So you should write and publish a privacy policy that lets the data subjects know what data you collect and how it's treated. You must establish a means of contact and also a data privacy officer. That's not officer, that should be officer, I'll correct that. Data subjects must have an opportunity to enforce their rights. So you have to have some form of point of contact within your organization for folks to send in requests for rectification or erasure or anything like that. There should be a process by which they do that. That's easy to do, not overly complicated. If you're a developer, so if you develop an application or some form of platform, you should understand and follow the concept of privacy by design. Again, this is reduce the kind of private information that you collect, and also make sure that it's properly stored within the application, whether that's through encryption if necessary or through some other secure means. And then if you're a service provider, you must have documented processes in place for things like privacy breach notifications and other stuff. So you should have your processes by which you make system backups, store content, separate users, provide a secure environment, and also how you plan to notify users in the event of a privacy breach. I should note, not in my slides here, but GDPR does specify a window for privacy breach notifications. I believe it's 72 hours that you would have to let any affected user know. And then finally, you really must integrate continuous review into your practices. So this isn't sort of a one and done kind of situation. You don't just check the GDPR item off your checkbox and then you walk away from it forever. You do have to make sure that especially if you're a developer, if your development practices, you make sure that GDPR is taken into account when you manage private data and sort of develop against that. And also, if you're a system administrator or a data processor, you really have to take this into account as you do your general job. So I want to go through one example of our process in action. This is sort of more of our actually, sorry, I will pause there once again for any questions that there may be.
So I know we have, while people are considering whether or not they have questions on what you've just gone through, James, and I know there's one there, but just a couple of points. Again, coming back to the earlier question about exemptions. So just probably a good point to highlight that there really is no exemption in the GDPR, under the GDPR, for the responsibility of those who are collecting this data to properly protect personally identifiable data. So just to be clear on that one. There are also, and I think this is a particular interest to researchers, the GDPR does have a definition of special categories of personal data. And these are generally sensitive data elements, and any organization or individual collecting that data needs to take special measures to protect that type of data, and includes things like political opinions, information about race, sexual behavior, genetic information, including genomic data. So, just that very brief partial list of what are called special categories under the GDPR gives you a sense that a lot of these special categories are in fact information that researchers collect during the course of a research project. So there also have to bear in mind that the responsibility to protect that information may well go above and beyond the kind of the standard approach when the information is particularly sensitive. And also the privacy by design piece that James mentioned was a Canadian creation by Dr. Anne Cavoukian when she was the Information and Privacy Commissioner in Ontario. And it's a worthwhile concept to review. There's lots of good information on privacy by design. So James, we have a couple of questions. One is, does the journal/PKP have to provide an information page for the person who might request erasure or a copy of their personally identifiable data?
Mm-hmm. So my understanding is they have to provide the opportunity for their data to be erased. So again, in the journal context, this would be a user account information, not, say, the submissions that they've submitted. And they also have to be able to provide a copy of their identifiable data as well. So within OJS, there's a means now to, say, download that data. They also provide them with access to the data, so they can rectify it if they want. They can self-rectify, basically, and they can manage their own data within the OJS user interface.
All right, next question. Are there recommendations for institutions without the capacity to move quickly on these issues? For example, can RDC provide a set of recommendations that can be presented to institutional leadership that helps make the case for non-trivial investment to compliance and establishment of policy and process? Did you want to?
I can make maybe a first attempt at this, and then Mark, if you have any follow-up answers, that would be great. So first off, I do want to say that this seems to be a really big issue, but you can break it down into, I think, more easy to approach components. And although there is a sense of sort of urgency to have something in place here, my understanding is that we're still in a bit of a grace period right now. So moving at all is more important than moving quickly. Or sorry, as important as moving quickly. It's more important to just start the movement process. Let's just put it that way, and to demonstrate some sort of initiative on your part to start tackling these issues. From PKP's perspective, what we've done, we have a sort of a multi-tiered approach because we are kind of a multi-tiered organization. But say from a software perspective, right? We have taken what we saw as the most important sort of fixes to the software to accommodate GDPR. We did those, and we tried to do those for May 25th. We almost got there. I think it was May 26th or 27th when we released that version. And that's in OJS 3 for those who use it. But there's still more to be done. And so we have a roadmap in place for that, and that's actually documented publicly in our GitHub. And it's important for us to be able to demonstrate that we're continuing to work on it, even if we're not perfect right away, that we do have a plan for that. And we do it as best as our abilities can do so.
And maybe just to add to James's comments, so just a couple of RDC specific ones. So this issue of the GDPR has been raised for the most recent RDC steering committee meeting, and one of the tasks that I have before me as executive director of RDC is to prepare a summary of the GDPR and issues from a high level. So that certainly is likely to move into a more publicly accessible document that may address that particular question with regard to recommendations that can be presented to leadership in our institutions. So certainly RDC recognizes that this issue is a critical one for the research community, and we will be looking at preparing at least some initial material this year that would facilitate preparation. As a privacy officer in 2 universities over the course of 20 years, I can say that Canada is probably better positioned than many jurisdictions in terms of privacy legislation. We have a fairly robust federal and provincial legislative framework for privacy, which applies in all provinces and territories, with one exception, 2 universities as well. So, I mean, I can say that one of the first steps that a leadership say, a university could take would be to look at their current privacy framework, working with their privacy officer, their privacy team, to just review the response that they currently have, and many have had in place for many years to respond to provincial legislation, and just try to get a sense of how that reconciles with the GDPR. And then I think that will raise obvious questions about things that do maybe seem to be elements that need to be worked on a little bit in more detail. But having said that, I don't think there's anything about the GDPR that would not resonate with Canadian privacy officers and specialists. It does raise the bar in terms of the responsibility to respond effectively, given the types of penalties and things that can happen when you don't adhere to the GDPR. So that's just a couple of comments. Another question, James. Providers are required to notify data subjects if their data has been compromised. I wonder if providers should also be required to compensate subjects if the breach impacts them negatively.
Mm-hmm. And I'm not 100% sure on this. My assumption is no, they are not required to compensate subjects, and that would most likely be spelled out in the terms and conditions of the actual agreement or the privacy statement that the data processor or data controller would specify. That said, I mean, we as PKP, we do for our clients, we spell out sort of basically a recompense scheme that we have in the event of, say, downtime or a security breach or something like that. So some groups may provide that, but I don't think it's required.
And maybe just to add to that, James, I think in most jurisdictions, the legislative framework that's in place, for example, in Canada, or obviously in this case in the EU, would allow subjects whose data is compromised to consider seeking compensation. But I don't believe that there's anything within the GDPR itself that facilitates this. Next question, can you speak to applicability, specifically EU citizens versus EU residents and personal information collection? How does the GDPR apply to personal information collected in a non-EU locals, given the distinction between these two groups? I'll let you take that, James. Not sure if that's
Yeah, and I'm actually, I'm not really sure. Like my recollection is that the GDPR specifies EU citizens, but I honestly, I don't know. I would have to look that up.
Okay, so we can, if that individual wants to have a response on that, feel free to email me or James, and we'll see if we get some information for you. Next question, does the GDPR apply to us because EU members may access a Canadian website? That is, why does the GDPR matter to us?
Yep, that's a good question. Maybe a little bit related to the last one too. So if you process personally identifiable information of EU citizens and or residents, we're jury's out on that right now, the GDPR does matter to you. It specifies those groups as the sort of the parties by which it talks about. So, I mean, it's as basic as if you have a website where you have visitors from the EU registering accounts, or even just visiting, and you have a tracking cookie, something like that on your website. Then it matters. The penalties aren't specific to EU or local to EU states. Theoretically, non-EU groups or organizations or individuals can be beholden to the GDPR if they're processing EU citizen data. In practice, I'm not quite sure how that's going to work, but in theory, it is very much consideration.
Next question, could you speak to some of the software fixes for PKP that were implemented to be compliant with the GDPR?
What I might do is I will talk about one of the sort of considerations that we went through, that feels maybe fairly PKP specific. But I can talk maybe about one particular fix that we did. That's sort of a broad fix that's sort of application agnostic. And that was basically adding an explicit consent statement to the registration and author submission pages. So previously, somebody would go to an OJS website and they'd register, and there would be maybe a privacy statement, sort of, as part of the registration process if the journal had provided one. But there was no explicit consent to understanding and agreeing to the terms of the privacy statement before registering. So that was that's new now. So there's now a consent statement there, and there's also the sort of the corresponding ability to agree to or withdraw from that consent on the user profile pages. So at any time now, and this is specific to OJS 3, by the way, at any time now, if a user using sort of an upgraded version of OJS 3, even now, if they registered, 2 years ago, or even 10 years ago, and it's now been upgraded to OJS 3, they have the opportunity, provided that data provider has updated the OJS system, to manage their consent within the application itself. So that kind of thing is important. And I hope that sort of provides one example of the process that we went through here to sort of establish how that works.
And James, I'll just, well, maybe I think I'll let you go ahead with the final section here, but just come back briefly to the previous question about why it matters, as somebody accessing Canadian website. And just to highlight that, any collection of data from European citizens, whether it's because they're leaving data behind when they visit your website, or because you as a researcher are working with European subjects or European collaborators. So there are a lot of reasons why a Canadian entity or organization may collect personally identifiable information aside from visiting a website. So I think any activity that causes that to happen would fall under the GDPR.
Yeah, and actually, let me maybe just make one other comment there too, because I do feel like sometimes the tenor of the conversation around this is sort of, how can I do GDPR without needing to, blow a lot of money or, get sort of, swamped by it or anything like that. And sort of after reading about this and talking with a lot of other folks about it and so on, I don't feel like it should be a truly tremendous burden in an ongoing way. It should become a natural part of the work that you do. These are common sense regulations again, and I feel like for me personally as an individual reading this, it makes sense, and I personally prefer, even as a Canadian citizen, knowing that these regulations are in place and that people are adhering to them, and we'll be thinking about them in an ongoing fashion.
All right, I'll let you go on with the next section, James.
Cool. So I did want to talk about one other sort of fun little weird area where we went down a bit of a rabbit hole in sort of PKP discussion land here. This is cookies. So you've probably seen, along with having about 2 million different privacy notices or privacy updates come into your inbox lately, you've probably noticed a new sort of upcropping of cookie alert statements on various websites. And at first I thought, this makes sense. You have to alert people that you're using cookies. There's a UK privacy law that's, stated this for ages now. And now people are, taking renewed interest in this. And as we sort of talked about it, in particular, sort of in the OJS context, we realized that there's a bit of security theater going on here. Security theater being sort of the term I would use, or people use to describe when folks like to make the appearance of doing something as privacy or security conscious, when in fact it's not complying or adhering to anything at all. And the cookie statement really is one of those, depending on your particular circumstance. So first off, GDPR doesn't say anything about cookies. It doesn't say you have to put a statement online if you have cookies or anything like that. There's no mention of it. The GDPR just cares about individual privacy and how that's managed. Second, there is a difference between session cookies and tracking cookies. So session cookies are used to manage website logins and to maintain your state in a browser. So if you go to a website, it'll register a session cookie so that you stay logged in and so that you're able to work with the website reasonably well. A tracking cookie does track your IP address and will track you, sort of your visit through the website and potentially even outside of that particular website. So quite typically other third-party scripts like Google Analytics or the Twitter stuff or whatever, those are tracking cookies. And those are problematic and definitely are issues with respect to GDPR. So sorry, go ahead, Mark.
James, just because it's very germane to your last point there, just one of the questions earlier was, what are the requirements in terms of third-party services that may be integrated within our software? So a simple example is using Google Analytics within a public-facing website. If someone were to request erasure, does that responsibility fall onto us or the third-party provider?
That's a good question, and it's actually made even more confusing by, say, the use of content delivery networks, or CDNs, if you know what those are. They're not cookies, but they're ways to include scripts and other information in your website from other networks that theoretically will speed up, or in practice actually will speed up your website in different locations around the world, but also contain potentially some tracking issues. So our suggestion on how to deal with this just in general is the simplest way is to not use tracking cookies and not use CDNs. And that is not going to satisfy or suffice for most people out there. They do have to use this, or there are going to be circumstances where they'll use it. With something like Google Analytics, Analytics does provide a way now, as my understanding, Google in general does provide a way to request the erasure or the deletion of personally identifying information. I am actually not sure whose responsibility it is. I assume that there would be some burden of responsibility on, say, in our case, like the journal, the website, to sort of minimally at least help process that request. But I'm going to just mark that as something to review and check up on. Because I'm not 100% sure. With Google Analytics, there is a way to set it up so that it does not track personally identifiable information. And really, it comes down to the IP address. There's a way to set it up so that it is anonymous and that it is no longer a concern. I have not done that for any of our journals as of yet, but it is available via the Google Analytics search console, the webmaster tool interface. But in general, if you do track that information, if you do use tracking cookies, you should be announcing that or specifying that one way or another. Session cookies are not a concern unless they, as a subsidiary effect, somehow track personally identifiable information. So my take from the recent sort of cookie uptick is that a lot of it is maybe unnecessary, but on the other hand, maybe it's just that a lot of websites actually do track that information all the time. That's it for my prepared notes. And it looks like we have, I think, 10 minutes left or so, Mark.
Yeah, so we have a couple more questions. And this is a simple question, but I think it's a somewhat complicated answer. The question is, what are the penalties?
Mm-hmm. I don't remember offhand. It is something like a certain percentage of your overall sort of income or revenue, or a certain flat fee, whichever is higher, basically. I should note the penalties sort of description, in my mind, is really geared towards corporations and folks who, for example, process personally identifiable information as part of their business model. And I haven't sort of delved too deep into how that applies to research centers or nonprofits or so on. But it's there's a scale depending on the type of penalty, but it can get pretty stiff.
Yeah, and just additional on that one, James, there's kind of two aspects to it. One is, what was the level of how severe was the offense? So how many of the kind of the determining factors in terms of fines were an issue? What the nature of infringement, intention, was there mitigation, were there preventative measures in the first place? So there are a number of factors under which these things are determined, but the fines, the lower level of fines is up to 10 million euros or 2% of the worldwide annual revenue for the previous financial year. And the upper level is up to 20 million euros or 4% of worldwide revenue. So as you say, I think the intent is to have penalties that are so severe that they would cause commercial organizations in particular that are using personal information to reconsider the nature of their use. But I think if there was a particularly egregious, ignoring of the GDPR in another context, a non-commercial context, I suspect there would be some consideration of how those fines would be applied. Next question. I won't read the full question, but essentially it is, can you address any distinction between the de-identification of personal data and the full destruction of data? In other words, if information is de-identified, is that sufficient? Or if it is de-identified and then made accessible, say through data deposit, an erasure would subsequently compromise that. Any thoughts on that impact?
And my understanding would be a de-identification here means effectively anonymization, in which case if you're removing personally identifiable information, then there's nothing effectively left to erase in that sense. But you do have to understand there's maybe a difference between sort of taking steps towards that and actually doing it. And so, removing, say, someone's name from a data set that also contains IP address information that, is very specifically linked to their house, there's still an issue there, for example. Again, probably not an issue for most research data, but maybe for general websites. So you do have to ensure that the anonymization is complete and effective in that sense.
And the last question here, and then I have a few closing comments, and I'll give you a chance to do the same, James. Canadian universities are likely developing policies on GDPR compliance. For a journal hosted by a university, what are the relationships between the university policy and that local journal?
Mm-hmm. So the university, let me back up here for a sec. The local journal should have its own data policy as a data controller. And in this case, in this sense, the university would be the data processor, most likely, effectively. And as such, should still have a data policy in place for how information is managed. In our particular case, because we have a service provider that we also rely on, so we have sort of three levels potentially. We have the journal, the university being SFU library, or SFU actually, and then our own sort of backend service provider. Each one of those has a data policy. They don't necessarily need to be published, and we don't necessarily need to preemptively provide the data policies to the journal for provision to users, sort of the end users, to publish, but they need to be there and available for audit.
All right, thanks, James. As I said, I just have a couple of closing remarks, but did you have anything else you wanted to say before we finish up?
No, that's it.
All right, well, again, thank you very much, James. It's nice to see a Canadian project like PKP, which is a leader in the open access journal publishing context, also take a leadership role in this context, because clearly from the registrations that we had for today's webinar, there's a great deal of interest in this. I have identified privacy and security of data, research data, as a key thread in additional RDC webinars. So if you have particular focused suggestions for webinar topics that would deal with the issue of research data and privacy and security, then please let me know. But you will see some additional ideas coming up shortly. I do track the privacy thing as well as other, obviously, developments in the research data context, and often anything that I find that I think is of interest, I post on the RDC Twitter account, which is RDC_DRC. So if you are interested in following along on things that seem to be important to this community, then that's a good way to do it. And finally, as I said, the webinar will be made available as a recording, both the audio and animated slide deck, as well as the downloadable slide deck. So with that, I'd like to thank everyone for participating in today's webinar, and look forward to providing additional information in future webinars. Thanks, everyone.
Oh,
Thanks.
and sorry, just one note. So I didn't realize that. Final note. Just to thank you, Mark, again for the opportunity, and also if folks do want to follow up, feel free to reach out, and I'm happy to talk about this further. Thank you.
All right. Thanks, James.
Take care, all.